Good afternoon, everyone. Thank you for joining the ISAS panel discussion on technology, social media, and regulation in South Asia. Today, we are delighted to have with us the following panelists. Ms. Meg Chung, Content Regulation Policy Manager, Head of APAC, Meta Facebook, Singapore. Mr. Shahzad Mahmood, Research Associate, Center for Governance Studies, Bangladesh. Ms. Shaimala Khan, Director, Research and Policy, Digital Rights Foundation, Pakistan. Ms. Shruti Shreya, Program Manager, The Dialogue, India. Today's session is chaired by Dr. Anuradha Rao, Founder, Cybercognizance, and Non-Resident Research Fellow, Institute of South Asian Studies, NUS, Singapore. Before we proceed with the event, we would appreciate it if the audience could switch off their microphones and videos throughout the session. The panelists are requested to keep their videos on. If you have any questions or feedback to share during the proceeding, please forward them via this chat. They will be consolidated for the panelists to respond to during the Q&A session. This panel discussion is live streamed on the ISAS Facebook page. I now invite Dr. Rao to make the introductory remarks and chair the session. Dr. Rao, please.
Thank you, Shavinia, for the introductions, and thank you to ISAS for the opportunity to host this session on a very interesting, complex, and critical issue. We have a wonderful panel today. A big welcome to you all, and I'm looking forward to delving deeper into these issues with you. And I see we have more and more audience members streaming in, and I really hope we'll get some good questions after the panel discussion. So let me begin by briefly introducing this topic. Internet regulation is rising in South Asia, as are online harms. And as many of us know, the internet in general and social media platforms in particular have become sites of contention for upholding and contesting democratic norms, accountability, as well as public safety and security. So this has resulted in the introduction or proposal of various regulations to curb the negative impacts of digital technologies. However, excessive restrictions could compromise user privacy, restrict free speech, and stifle innovation. I'll be asking the panel about these issues, as well as the current state of affairs with regard to social media and internet regulation in their respective countries. We'll also talk about what some best practices are or could be in this regard. And I want to ask them also how these contestations could pan out and what they feel are the larger implications for the region. So I'll begin by asking a broader question about the social media landscape in South Asia, and I open it to all the panelists. So we know that social media deeply affects societies, politics, and economies across South Asia. From your own line of work, what are some critical trends that you see here? Maybe I'll ask Shruti to start off with the India perspective.
Definitely. Thank you so much, Dr. Rao, for setting the tone of the discussion. And I would just like to begin by stating that social media has had a very deep impact on the way the Indian society has evolved in the last couple of decades. Be it any stream, be it education, be it health, be it business, or be it just shaping public opinion on any issue, be it giving a platform to people to voice their ideas, their thoughts more openly and bringing people closer. Social media has had one of the deepest impacts, and I think India is one of the largest contributors in the social media space, be it in terms of the number of users, or the number of companies that have been able to set up their businesses here. So social media is a key driver of both the economy, the politics, and the growth of Indian society in general. Definitely, the Indian development, social media has had a great contribution. However, in the coming years, in the last few years, we have witnessed that the growth has also led to some safety challenges, some critical law and order concerns, leading to different kinds of regulatory approaches being proposed. Like in India, if we see, we have the Information Technology Act of 2000, which is the principal regulation that governs the social media space. And then there have been delegated legislations made therein to regulate content and social media intermediaries in general. We had the Intermediary Liability Guidelines of 2011, which were very recently amended through the IT rules of 2021 that brought about some very interesting regulations and some new prescriptions in place. So there has been, and now the government is also considering the revamp of the entire Indian IT Act. The Digital India Act is under consideration. These are some of the important, significant moves. Definitely, there is a need to ensure effective regulation of the social media space. But research shows, the research that I've done, the research that has been done by the civil society at large, or what experts have been pointing out, that it's important to ensure that any kind of regulation is principle-based, and it takes into consideration the right to free speech of the people and the demands of the digital economy. So in the going forward discussion, I would love to discuss some of the crucial ambits that the legislations in India propose, how they have impacted the economy and the digital rights of users, and how we can ensure that we take some learnings from the international best practices, and how we can make our regulations and regime more empowering for the users, progressive, as well as the considerations of safety and security are well catered.
Okay, thank you, Shruti. Thank you for giving us a basic, a baseline with which to start with to understand what the situation in India is like. And I'll ask Shazab next in terms of the Bangladesh context, and if there are any striking trends in your own line of work that you feel that you would like to highlight here.
Sure. So the impact of social media on education, on entrepreneurship, empowerment, access to information has been quite profound. Just to quote a few statistics from Meta itself, like more than 70% of female-led businesses in Bangladesh were set up on Facebook during the pandemic. There has been 65% increase in Instagram businesses owned by women, and 40% of Facebook groups about entrepreneurship have been created by women since 2021. Now, small and medium-sized businesses in Bangladesh contribute to 25% of the country's GDP, which translates to approximately 120 billion US dollars. Now, if you slice that figure to subcategories representing SMEs that was started on or facilitated by social media, the amount would still be in tens of billions, I suppose. And a large number of these companies are also receiving foreign investments. So just one example, a transaction I was involved in advising the investors, a multi-billion-dollar venture capital firm. It was an edtech startup, started a couple of years ago on Facebook, on YouTube, and then ended up receiving multi-million dollar investment. And there was a point where they had to say no to a couple of big investors. And the effect of these progressions seem to have ripple effect in other areas. So just to give you an example from the financial sectors, according to the central bank statistics, in June 2022, this year, approximately 9.4 billion US dollars was transacted using 64 million accounts just in the MFS mobile financial services only. So this is completely excluding the banking sector, the formal banking channels. Now, MFS has become a big thing in Bangladesh, and a lot of these Facebook-driven, YouTube-driven businesses, the SMEs, are using MFS to conclude transactions. Just on a final note, I would say that the government policies have also been generally conducive towards this progression. One example could be Vision 2041 of the government, which generally treats ICT and social media as a good driver of economic progression. Thank you. Over to you, Dr. Rao.
Thank you, Shazab. I like that you've chosen to focus on the financial and the economic aspects of social media as a driver in the Bangladesh economy. Thank you for that. I'll move on to ask Shamaila what she would like to highlight from the Pakistan context.
Hello. So in Pakistan, a lot of the focus
around regulation of online spaces and sort of on the way in which online spaces have played out has been along more social and political lines. So the government's focus, for instance, overall has been to regulate online spaces through cybercrime legislation and through content moderation legislation that is aimed at ensuring control over companies and tech platforms. And but at a society level in Pakistan, we have seen that social media has been transformative in some senses. It has been the reason a lot of movements have flourished and sort of found spaces, especially when sort of other alternatives in terms of expression and mobilizing have been foreclosed due to other sort of laws or restrictions. So we've seen sort of in the last 7 to 8 years a mushrooming of youth-led movements, student movements, women movements, movements from sort of around long-standing issues around sort of from the peripheries with regards to enforced disappearances. And a lot of these have coalesced around online spaces and digital platforms. So in that sense, they've been really transformative. But at the same time, a lot of these, it has also been quite devastating for marginalized groups as well, as we've seen the proliferation of hate speech, online gender-based violence. But and now we also see very clearly that there are very, very clear pathways and sort of structures to ensure state narratives and disinformation that is disseminated, which is a major concern and a major motivation for why the government wants to control these spaces as well. So we've seen sort of a tightening of the state's control over these spaces, or at least attempts to do so, while at the same time there has been a corresponding sort of flourishing of speech as well. So that's been sort of the overall impact. And I think during the pandemic, we saw that there was an exponential also growth in terms of access. So access is still very, it plays out along class and gendered lines. In terms of the economic aspect, there have been aspirations by the state and the government to ensure that sort of the tech industry within sort of local tech industry is given support. And the government also went as far as to launch sort of programs such as the Digital Pakistan program in 2019. And that was supposed to be sort of the high point of increasing investment and sort of focus of the government into these sectors. But we've seen that that hasn't really played out due to larger economic reasons. The country has spiraled into economic crisis in the last few years. And a lot of the tech industry has struggled to under the weight of sort of regulation that doesn't seem to be facilitating rather than and rather is creating obstacles in terms of sort of growth in that field. So that's something where Pakistan has lagged both sort of at the governmental level, but also generally at the industry level.
Okay, thank you. A lot of paradoxes there that you've highlighted when it comes to social media and its impacts on society, politics, and government. And I'm going to, as we talk about the paradoxes of social media, bring in Meg, who can also answer the same question, but from a social media company perspective. Meg, what are your thoughts about the role of social media here?
Yeah, I would echo a lot of the comments already made by Shazeb and Shmaila and Shruti, but I'll look at it from a broader viewpoint of social media. I think in terms of the positive impact of social media, we've already talked about how transformative it's been. It's a driver of the economy, and that's for sure. We've seen a lot of growth, especially in commerce, as well as in other areas that it's being driven through social media. But I think the one big thing is how social media has really helped democratize information and more voices. So there's a much more diversity of voices now that are operating in both the political space and in the social space, that has allowed people that has really empowered traditionally more less powerful voices to be able to come out and really speak up and hold different policymakers, politicians more accountable. But I think there's an adverse effect to that, because when you start doing that, when you start spotlighting holding accountable and start spotlighting what people those that are in power are doing, then there's the adverse effect that we're definitely seeing in South Asia, where you're seeing more and more regulation being used to censor voices instead. So to what you were saying about paradoxes, we see that social media is democratizing and transforming and empowering more voices, but then it's also then leading to governments feeling like they need to regulate in a way to censor these voices as a counteraction or a counter effect. So there's this constant balancing that we have to do in terms of impact on society, impact on politics, with the pros and cons and the benefits, the cost and the benefits. So I think that's one of the things that in terms of our discussion here, in terms of impact on social media, on society, or on politics, we're constantly talking about safety versus privacy, versus economic growth, versus free expression and other human rights. That it's this constant balancing act that we're going to have to take. And there are no clear lines that you can draw right now, because it's also constantly shifting, because society is shifting as well, right? So it's just constantly looking at what are the risks, what are the benefits, and then, yeah. So I think that's kind of how I would address that question.
Great. Thanks, Meg. Like you said, there's a lot of contestations, a lot of paradoxes. And of course, we've seen increasing contestation between governments and tech firms happening around the world. And this has been happening for some time now. So I want to again take it back to the panel and ask, in your own experience, do you feel what similarities or differences do you see between your own country and in terms of other contestations between social media companies and governments around the world? Anything similar, different, Shruti?
Thanks, Dr. Rao. So I feel that the social media regulation debate is shaping very similarly across most of the prominent democracies of the world. Most of the governments have said that national security and online safety is a critical challenge for them. And the need for more accountability from platforms has also been highlighted across the board. Most of the countries we see are taking some step or the other to sharpen, if I may use the word, the safe harbor provision or the safe harbor protection that is given to the social media companies. Like Section 230 of the Communications Decency Act of the US, it had said, and it established the principle of safe harbor, which is that the companies will not be liable for user-generated content if they do not have actual knowledge of its illegality. And this has been one of the most crucial principles that has created the open and the free nature of the internet. However, now we are seeing, be it in the EU, we see the Digital Services Act coming on. In the US, we saw that there was a legislation passed in Florida and the recent White House directive. So all these point towards demand for greater accountability from platforms and some new due diligence mechanisms or requirements being prescribed. Governments are demanding for more transparency in the algorithms that the platforms are using. The government is demanding for more coordination between the platforms and the law enforcement agencies. In India as well, as we see at the IT rules of 2021, new points of contact have been mandated to be established, be it the chief compliance officer or the nodal officers, who would be the point of contact between the law enforcement agencies and the social media platforms. Then there has been proper channels prescribed for content takedown, content blocking, and mechanisms have been prescribed that if certain order is given, then the content is supposed to be taken down within a prescribed limit of time, which is 36 hours generally, and then for certain more sensitive nature of content, it's even lesser. it's important to understand that while most of the governments come from a legitimate point of view, and definitely safety is a crucial point, but the way these provisions are shaping up and their feasibility is something that needs greater deliberation. Definitely, there is need for greater accountability and greater coordination is required. However, the kind of restrictive content blocking or takedown mechanisms that's being prescribed is not the very best way forward. Similarly, all the impact that these kind of regulations have on the safe harbor provisions in general also needs to be deliberated upon more. Like the judiciary across the world has been saying that the open and the free nature of internet is critical because digital rights is a very important part of human rights. So definitely maybe a more graded approach and a more coordinated approach across the world in terms of regulating the social media space, since most of the companies work and operate across jurisdictions. So maybe a globally recognized and accepted framework which is similar and consistent and which doesn't lead to over-regulation, because if there is over-regulation, then that's not just detrimental for the economy, that's detrimental for human rights. Any kind of restriction on safe harbor is going to lead to greater censorship by the companies because they have to protect themselves and their employees from any kind of liability. So that might need to lead to greater censorship, and then the brunt is going to be felt by the people at large, especially the marginalized communities. So these things have to be taken into consideration because, as Meg also pointed out, safety versus free speech is a debate, but both need to be achieved in a balanced way. Any impact on safety, any impact on free speech or privacy has a direct impact on safety as well. So it's not that you can achieve one while compromising the other.
Thank you, Shruti. There was a very comprehensive overview of what some of the sticky points are with regard to regulation. So I'll move on to Shahzab and after that, Shamaila, to ask you the same question, which is, do these contestations, the regulation that's happening in your countries echo what Shruti has said has been happening in India and what we see around the world, or are there some things that are a bit different?
Thank you, Dr. Rao. I echo much of what Shruti said, but just to point out that corporation locking horns with the government, or indeed lobbying the government, is not exclusive to tech industry. What we have been seeing over the last few years in Bangladesh is the government saying that because of a lot of these non-resident tech companies, they're losing sovereignty, control over content regulation, over how they're governing the country. And again, that is not exclusive to Bangladesh or South Asia, because to a varying extent, other countries are facing the same problem. Just to point out, this one very interesting case that I was reading from Australia, where the court wanted to penalize an internet company based on a certain percentage of the turnover. But the entity situated within the jurisdiction was a sales and marketing subsidiary of the principal company, and the turnover was quite minimal. So there was this very interesting question of whether to penalize the parent company or the principal affiliate outside the jurisdiction. Just circling back to the whole question of sovereignty and control. In regards to your question very specifically, I think content regulation in Bangladesh and to some extent in South Asia is probably driven by religious and political consideration more than it is in the West. Violent communal disharmony is becoming more and more frequent in Bangladesh. We've had very problematic situations in the last 3 years alone. And this is having an impact on policy formulation. The online content regulation that we are currently formulating, I'll talk more about this as we move along, but just in a snapshot, they've introduced requirements like traceability. They've introduced requirements like turnaround time for content moderation within 72 hours. Now, a lot of these requirements will have a direct impact on privacy consideration or right to free speech. It would lead to self-censorship. So yeah, just to echo what Shruti said, it cannot be a trade-off between privacy and free speech. There needs to be a pitch perfect right balance between the two in order to ensure that these policies are inclusive, are technology neutral, are, so to speak, timeless. Thank you very much, Dr. Rao.
Thank you, Shazab. I see that, that's something that we'll discuss as we go along, which is what is that balance and how do we move closer to getting that right, formula, so to speak. But before we get there, Shmaila, your thoughts about Pakistan being similar, different, what's happening there?
Yes, I'd like to echo what both Shruti and Shazab were saying, that in Pakistan, sort of as a user, you are caught between two sort of very difficult positions. One is where obviously there are a lot of harms and a lot of issues in terms of the right to privacy, inadequate content moderation by tech companies. But the alternative, which is being presented to most citizens, is that means sort of shifting over that power imbalance to the state, and the state being sort of the arbiter of how these companies should act, and the state should have more control. And the problem, what ends up being is very similar to and gets in sort of the kind of discussions that are happening within India and Bangladesh as well, that there is this a sort of civil society, for example, or rights groups are very conflicted because while we are no fan of tech companies and sort of there is a lot to be done in terms of transparency and accountability, the alternative being the state sometimes is the immediate, as an immediate option, is much worse in terms of human rights, because the state, for example, if it does have access to that data, if it is given the right to sort of what content should stay on these platforms and what shouldn't, that can lead to a lot of violations in terms of anybody who is sort of taking a so-called anti-state stance, is dissenting. So I think sort of we're caught in like a very difficult space where individual users don't really have a third alternative, and they're made to choose. And a lot of times, a lot of sort of the position that the society has had in these past 2 years has been to defer probably to tech companies more, because there's a lot more chance of sort of a human rights angle being maybe appealing to them, as opposed to the state, which is very much sort of vested with sort of this incentive to control the internet even more. So yeah, I think it's a very similar pattern that is emerging there as well.
Thank you, Shmaila. I like how you posited this as the user, the internet user, really, being between these two big power players. And a lot of times we really don't have much of a choice. So how do we create situations where users themselves have maybe more autonomy or greater safeguards for themselves? I think that's what we're going to be discussing further also, right? How much autonomy, power, privacy does the ordinary internet user have in these kind of situations? But I'll sort of zoom out a bit and get Meg back in, because the question, Meg, is from your own perspective, where you're handling these different countries, you're looking at what are you use, again, the same question, similarities, differences, and within South Asia and between South Asia and the rest of the world. I'd love to know some of those little, the little interesting trinkets of information you have for us.
Yeah, so let me just pan out first, and then I can then zoom in a bit further. So panning out, like based on what Shruti and Shazab and Shmaila have said, like I guess the way I would sum it up is there's this ongoing tension between fragmentation and harmonization when it, in terms of how the internet operates, especially when it comes to content moderation or content governance. But then you can kind of like that fragmentation and harmonization, you can also put it down to it being about like digital protectionism or digital sovereignty, where governments want to benefit from the economic, like they want to have the economic benefits of the internet. So like a lot of our discussions as a tech company with the government is very much about like governments wanting social media companies like Meta to invest more there and to help continue economic growth, right? So then they tread carefully when it comes to regulation, when they think that it's going to impact economic growth. But at the same time, there's this other line, like what Shruti was saying about national security and safety, that they're also trying to balance. But also there's this concern about government criticism, like with the political speech aspect of the discussions, of like a lot of the online discussions, that they're also wanting to perhaps have a bit more, I don't necessarily say control, but they want to necessarily be able to, I guess, censor that to some extent as well, under the guise of national security and public order and safety, et cetera. So there's this constant balance that like tech companies are stuck in the middle of, where they're trying to like deal with this concern about protecting speech of our users, and then also then at the same time dealing with the government's concerns. And so going back to like safety versus free speech versus privacy. So in terms of the power dynamics, then we get kind of put in the middle as well between the user and the government, especially in the South Asian countries, where we get a lot of, we have a lot of discussions in civil society where tech companies are the only barrier or the only mechanism that they can utilize to protect their own voice on the platforms, because they themselves are not able to. And then at the other side, we get the pressure from the government to censor. And then on the user side, we're getting the pressure, on the civil society side, we're getting the pressure to ensure that we are protecting and respecting users' rights and free speech. So there's this constant, like what you were talking about, contestation. And at least from a meta standpoint, we're kind of in the middle of this, where we're trying to balance user rights, human rights, and then at the same time, government concerns. And then also like trying to ensure that everyone that's operating is benefiting from like the economic as well as social benefits of the social media platforms. So I think that's kind of like the fragmentation, harmonization kind of all kind of like basically focuses on those issues.
Right, Meg, thank you. I just also wanted to, the follow-up question was, do you see any differences between what governments are doing within South Asia, or does it seem to be largely following the same track?
No, I think that's like the question around digital sovereignty seems to be like a broad concern across all countries to some extent. But at the same time, like that concern really depends on whether the country is a supporter of the open internet or not, right? To what extent they are willing to go to have that digital sovereignty yeah. I think like in terms of like regulatory approaches that we're seeing, there's like this very content-focused approach that we're seeing in South Asia, where governments are trying to determine like what kinds of content should not be on the platform, should be restricted altogether. And this then starts bumping into questions about censorship and violations or infringement on free speech and expression. Versus this more systems and principles and risk and outcomes-based approach that you're seeing, like, for example, in the Digital Services Act in the EU, and also like you're seeing this, like there's a more cautious approach when it comes to human rights and human rights violations that is being undertaken by like Europe, the UK, and even all the discussions in the US around Section 230 reform. It's more of a systems-based human rights respecting approach to regulation, where they're not trying to define what is illegal, because the definitions that we're seeing of what is illegal and a lot of the regulations that we're seeing in South Asia are very, very broad and vague, right? Where it could basically capture anything under the guise of national security. And whereas you see in like the EU and the UK, they're much more cautious about like very narrowly defining what is illegal and criminal. And then really leaving the rest to like more risk-based, systems-based outcomes and types of regulation, where going to what Shriti's saying is really focused on transparency and educating the users and empowering users and really like enforcing and facilitating digital rights for the users. And so those are like the two kind of different approaches that we're seeing. And of course, for us, we believe that the more systems-based approach is actually more effective, because it's really trying to tackle the systemic issues. So really trying to focusing on like building digital citizenship, making user empowerment, whereas the content-based approach, which is about defining what is illegal and then removing it after it's already been on the platform, is a very reactive approach that doesn't really get ahead of the concerns and the problems that the governments are trying to address from a safety point of view, at least.
Okay, great. Thank you. There's so much of information there. I'm going to come back to you, after a while and just ask a few more things, because so many more follow-up questions. But I'll go back to the other panelists and want to get a better sense of the current status of the internet and social media regulation in your country. I know that we've talked a bit about it, but if we could just delve a bit more in terms of who are the key stakeholders here, and in terms of what are the larger conversations? Is it content? Is it human rights? Is it censorship? Is it digital sovereignty? What are those key terms that are thrown about more in context of your own country on this issue? Shruti, would you like to kickstart that?
Sure. So as I already mentioned, the IT Act of 2000 is the principal regulation for regulating the social media space here. Therein, if we see, so there is section 79 of the IT Act, which talks about the safe harbor protection, which is given to the social media companies. And the social media companies are supposed to enjoy the safe harbor protection if they exercise due diligence. And some of these due diligence mechanisms is also prescribed under some rules formulated under section 79 of the IT Act. So like the IT rules of 2021, they elaborate most of the due diligence requirements from the social media companies in order to enjoy the safe harbor protection and be immune from liability arising out of third-party content. Some of the major things that the IT rules of 2021 prescribe are mechanisms for takedown and blocking. Like if the government gives, or a law enforcement agency gives an actual notice to the social media company saying that certain content is violative of law and order, or it violates certain law, the company is supposed to take it down or block the content within 36 hours of receiving that order. And if it's related to any sexually offensive content, this action has to be taken within 24 hours. While it is important to have the mechanisms for blocking and takedown in place, there are certain problems given the straight-bracketed singular timeline which has been prescribed of 36 hours, or let's say 24 hours. Content gradation is something which has been prescribed by experts across the board as a more feasible requirement, wherein if you can grade the content, say something which is posing a national security issue, if you give them a shorter timeline, but something which is, say, a copyright infringement or a contempt issue, you can give maybe a larger timeline of 4-5 days. So this is a problem. The lack of gradation of timeline is a concern there. Another important thing is the chief compliance officer, who is supposed to be the main person to ensure that the company is complying with all the due diligence requirements. This is a very significant move, and it's in fact a commendable move because accountability is definitely a critical issue, and the compliance officer situated and resident in the country will ensure that there is better coordination between the law enforcement agencies and the social media companies. However, there again, a mechanism is being prescribed wherein the chief compliance officer can be personally responsible and held personally liable in case the company fails to adhere to any of the requirements. And in fact, if this is read with section 69A of the IT Act, this kind of liability can also be criminal in nature. So this can lead to a lot of economic hardships for the companies to hire people for this position, which in fact we've seen in the past also. And recently we did a study on this as well, for which we had also interviewed Dr. Rao. And we found out that this kind of criminal liability is not conducive for ease of doing business. And this can also have free speech implications, where the companies can censor more in order to save their employees for certain kind of criminal liabilities and the costs that can come with it. Another important thing under these rules is originator traceability on messaging platforms, like end-to-end messaging platforms like Signal or WhatsApp. So the government says that in order to know who the first person who is proliferating a fake news or a misinformation, they want to know the first person who had shared a fake news, and they want that whenever the government comes and says that we want to know the first person who would send this message, the platform should be able to do that. However, currently there is no existing mechanism which can enable the platforms to do so on an encrypted platform. End-to-end encryption means that the sender and the receiver can only know this. So this can have large fetching implications for privacy specifically, because encryption is one of the most critical safeguards of privacy. And this can lead to some geopolitical implications where the companies which are operating across countries might have to change their business models to adapt themselves for this mandate in India. So this is something that needs to be looked into. Another critical consideration, very quickly, I would like to touch upon is Section 69A of the IT Act. So Section 69A of the IT Act says that it prescribes the entire manner in which if the law enforcement agencies come to the government for saying that a certain content is problematic, then it's supposed to be blocked or taken down. It's a necessary provision to be there. However, it's important that necessary checks and balances are put in place on this kind of provisions. So like right now, the provision is very wide in its approach. It doesn't delineate who exactly can these officers be, who can coordinate with the government, which leads to a lot excessively, like any government official can come with such a notice and demand the takedown. More importantly, the review committees that's constituted under the blocking rules that have been formulated under Section 69A. It needs more representation from judiciary, from civil society, from women, child rights experts, because it's important that the authenticity and the legality of such orders that's passed by the executive is consistently reviewed. And another important thing is that the blocking rules permit that in certain situations, if say there's a national security concern, the government doesn't have to disclose the orders, the blocking orders that it passes. In fact, under the IT rules of 2021 also, the companies are supposed to disclose the number of content that they take down through proactive monitoring or through the complaints that they get on their grievance redressal portal. However, the government, orders that the government gives for takedown and blocking is not mandated to be disclosed under the IT rules. So disclosing the government-initiated takedown and blocking numbers and also the public availability of the orders that's passed under Section 69A is important for people to exercise their right of judicial review and also to exercise constitutional remedies, access constitutional remedies, and for the judiciary itself to exercise its power of judicial review. So I think now the Digital India Act is being considered to be...
If I could just interrupt you for a minute, and I will get back to your point about the Indian context, because you've raised some really important issues about what are some of the key conversations happening in India and what are some of the challenges. So I'd also like to pose this to the other panelists as well as to if you feel that some of these same issues that Shruti has raised resonate in Bangladesh and Pakistan, and you want to raise something else, please feel free to go ahead and talk about other conversations or other challenges that you see happening in your country. Shazab?
Thank you, Dr. Rao. So the development and implementation of internet regulation in Bangladesh has been reactionary. It's been slow. It's been controversial, to say the least. So there are two aspects to it. The first is cybersecurity, digital security. On the other hand, you have the online content regulation. So since 2006, we have had some form of cybersecurity law. We have had Information and Communication Technology Act, 12 years of that, and then we have Digital Security Act. Center for Governance Studies, for example, has been tracking cases filed under Digital Security Act, and between January 2020 and February 2022, there's been over 2,000 arrests made under the cybersecurity legislation. And just to give you a sense of the pattern of these arrests, most are politically motivated, and the content in questions are, from a very objective perspective, they're permissible in nature, should be permissible in nature. We have had arrests of politicians, of teachers, of journalists, and of minors during the pandemic itself. So one very interesting example is a 15-year-old who was arrested because of some satirical post he made on Facebook about the political leadership. Even the law minister of Bangladesh has conceded that the law is being abused, it is being misused, and there's a need for caution. But in all honesty, little has changed since the statement was made. there were constitutional challenges to the law as well. Writ petitions were filed, probably in 2020 or 2021, don't remember. But effectively, it was filed to declare the vague, the ambiguous provisions of the law unconstitutional, but there has been no meaningful development here. Now, moving on to the other bit, which is the online content regulation. So over the last few years, we've seen a slew of public interest litigations, either for the introduction of online content regulation or for the removal of individual contents. I have counted at least 7 since 2019, but there could be more. The last one was filed in August 2022. In one of these PILs, the telecom regulators and the information ministry were asked by the court to draft regulations. They did that, but they did so separately. So now we have 2 frameworks dealing with the same set of matters. So the telecom regulator went ahead and transplanted the regulation from the problematic Indian IT rules of 2021. So they have now, for example, requirements like traceability, which Shruti has quite beautifully explained. We have turnaround time of 72 hours, slightly more than India, but 72 hours with no graded approach, no proportionality requirement. We have criminal and individual liability that goes to several million US. Unlike the Indian IT Act, which contains safe harbor, robust safe harbor provision, the Telecom Act, under which this regulation is being framed, it does not have safe harbor provision. In effect, there is no safe harbor provision in the regulation. Also, there is no requirement for providing duly reasoned takedown requests. There are vague and overly broad definitions. So these are some of the key highlights of the BTRC regulation that we have. On the other hand, you have the Ministry of Information Policy, which takes a very one-dimensional approach, seemingly treating all internet intermediaries in the same way. So technically, there's no difference between user-generated content hosts and curated content hosts. It also requires these internet platforms to follow the broadcasting policy. So it's been drafted from a very legacy broadcasting perspective as well. Now, there has been some talks about this framework being stress tested by amicus curiae. There has been some consultation by the government with the industry experts, but in all honesty, we haven't seen those comments being, feedbacks being reflected in the latest draft of the regulation. We'll see more as the next date of the case is on the 19th, which is exactly a week from today. The other last bit of information I would like to share is that the government is also in the process of drafting a data protection legislation, which very specifically contains data localization mandate. That data localization provision contains reference to user-generated data, user-generated contents. So in effect, it means that user-generated contents will have to be stored in Bangladesh, and there are some restrictions on cross-border data flow. What's problematic about this approach is the fact that the government's trying to use a privacy framework to enforce content regulation, which makes little to no sense. Now, on the whole, these frameworks have attracted criticisms from Transparency International Bangladesh, who's called these regulation is moving Bangladesh towards a surveillance-based country, to Access Now, Global Network Initiative, Internet Society, Amnesty International, Asia Internet Coalition. It'd be very interesting to see whether the government positively responds to these criticisms and feedbacks. Thank you, Dr. Rao.
Thank you, Shahzeb. You've added on so well to what Shruti said, and you've talked about the problematics of the way the laws or regulations are being framed in Bangladesh. I think something that really is very something to be fearful of is the fact that if you don't have safe harbor provisions and the personal liability angles are just something that for me, I would use the word fearful when I'm talking about it. So there's something to really think about in greater detail here. Shamila, would you like to add on about the Pakistan context and the conversations that are happening there around the regulations there?
Yes, actually, there's a lot of overlap to the extent that it was eerie to hear. It's almost sort of it's a very close reflection of what's going on. But it's just to sort of, I hope I don't end up repeating some of the same beats that the other speakers have been alluding to. But in Pakistan, internet regulation and has been primarily for a long time been under the criminalized framework. So the Prevention of Electronic Crimes Act, which was passed in 2016, and there were sort of vestiges of that that approach in other pieces of legislation before that, which were consolidated under what we call PISA. Under this act, we saw that there was sort of the issue of criminalizing a lot of speech, such as criminal defamation, and it also gave under Section 37 the powers to the regulator, which is the Pakistan Telecommunication Authority, to regulate a lot of content under very wide criteria, which included sort of morality, safety and security of Pakistan, the integrity of Islam. So all of these sort of very, very wide ambit resulted in a lot of overt censorship by the PTA and non-transparent removals and blocking of content, which even resulted in blocking of entire platforms in Pakistan. Famously, for a very long time, for almost 3 to 4 years, YouTube was banned. Periodically, all major social media platforms have been banned. In the last 18 months, TikTok was banned 4 times and then reinstated. So there's a lot going on in terms of blocking and removal of content. Under Section 37, the government in 2020 tried to pass the social media rules, which further expanded the powers of the PTA to remove and block content. Ultimately, there was a lot of pushback, and the government came back with virtually the same kind of regulation in the form of removal and blocking of unlawful online content rules 2021. These were immediately challenged at various high courts across the country for both sort of exceeding the ambit of the Parent Act, and as being ultra vires, and also sort of violating larger fundamental rights such as freedom of expression, access to information, right to privacy. These rules are currently notified, and the court has fallen short of sort of completely doing away with them, but they have told the government to take these to a parliamentary committee and then for these to be revised. That has not happened yet, so effectively the rules are in under operation. These rules also require social media companies to register within Pakistan and to have representatives within Pakistan. This is something that social media companies have resisted because similar to the kind of framework in India that the government is trying to bring, it could result in sort of penalties for individual employees of the social media companies. And the rules also suffer from the fact that there isn't a robust appeal mechanism for the kind of content that they do block. Apart from that, under the framework under PISA, there has been a lot of issues with regards to sort of criminalization of speech, especially around like sort of how the hate speech provision has been used, which is Section 11, and it's Section 20, which is criminal defamation, that has been used to target a lot of journalists, for example, women speaking out against under the Me Too movement. Just earlier this year, part of Section 20 regarding criminal regulation was struck down by one of the high courts, but upheld by the Lahore High Court. So that means there are currently 2 conflicting judgments which have, and the case has now gone to the Supreme Court. So that is sort of, there is that contestation in terms of how the landscape is looking like, but ultimately there is a lot of over-regulation and which made sort of the state and tech companies the major stakeholders in terms of these spaces. And then, but obviously there is the people who are impacted by it are journalists, activists, civil society, users. There is also the issue of sort of while privacy is a sort of constitutionally protected right in Pakistan, there are no specific rules regarding data protection and personal data protection. The Ministry of Information Technology has put forward a draft of the data protection bill, which is currently under consideration. But one of the biggest problems with it is very similar to what's happening in other countries in the region, that there is a sort of the more, and I think there is a fair degree of like sort of borrowing from other examples as well, and that's why sort of it's very important that we have these conversations, because one country can set the precedent for another. So there is a call for data localization, which it runs into a lot of issues, obviously, but also sort of is not something that is entirely practical. But the government has insisted on it, and despite sort of going through several drafts, that is something that they do want under the social media rules. For example, tech companies are required to hand over any data that the investigation agencies require them to in an unencrypted form, which is also a big issue. And most recently, the government has also given calls for registration of VPNs under these 2010 rules, the monitoring and reconciliation of telephony traffic regulations. And there it claims that it has the authority to ask for registration of VPNs, which is counterproductive to what VPNs do. So that's also something sort of in India, there's also this sort of push by the government to also regulate VPN. So that's been one of the issues, but that hasn't been enforced to the same extent as these other rules. But that's something also to flag in terms of what the government is doing. And they have been also proposing. Yeah.
Sorry, if I could just interrupt you for a minute, because you have said so many great points that I want to just quickly condense before I move on to Meg, which is you've talked about the issue again, that what you said was many of these laws look very similar. Many of the regulatory frameworks appear to be copied, or not a very good word, but appear to have been influenced from one another in the region. And so this is a great example. If we would reverse it to think of, if we can think of best practices, then perhaps those best practices would spread also in terms of regulation across the region. And that's one way that your statement got me thinking that maybe we'll have to spend a bit of time to talk about that. But I just want to change the conversation a little bit and ask Meg this question. And I'm sure, Meg, you've heard this a lot of times, which is that one of the main reasons cited for social media regulation is that they have a propensity to cause a multitude of online harms. And we've seen recently with one of the recent incidents is the publishing of the Facebook papers, which highlights these dangers, particularly in relation to South Asia. So I wanted to ask you, what steps has Meta been taken since then to ensure that its users are better protected? And then the next question would be, if we look at regulation in terms of this intent to better protect users, what have social media companies been doing, or what can they do?
Sure, thanks for the question, Anu. So I think to start off, I just want to kind of clarify one of the misconceptions or beliefs following the Facebook papers, that Meta hasn't been doing anything and now we're finally doing something because these papers leaked. And that's not the case. I think what the papers have shown is that we invest a lot in research. We invest a lot in our integrity products and teams to basically continuously assess and mitigate the risk to our users. Because, you know, if we don't have users on the platform because they don't feel safe, then we won't be able to continue operating, right? Because so I think that's one of the key things I want to first highlight, is that like the Facebook papers didn't instigate us, or wasn't a catalyst for us to act to do more because we're already doing a lot. And it's this, so it hasn't changed our course in terms of the ongoing investment that we're doing in this space. So like at this point, we have like 40,000 people, over 40,000 people working in safety and security across the company. That covers over 70 languages. We've invested more than $13 billion in safety and security since 2016, and just in 2021 alone, we invested more than $5 billion. So and this wasn't like anything that had to do with the Facebook papers. So in terms of our strategy for dealing with online safety and harmful content, policy, like there's a 5-part strategy. First, our policies. And we're constantly on an ongoing basis reviewing our policies and updating our policies to address like the most concerning issues of the times, because online threats, online harms are constantly evolving. So of course our policies need to evolve too. And we don't do it in a silo just within Facebook or Meta that we're just talking about this. We're doing it in partnership with a lot of different civil society groups, academics, experts, all around the world. And so you can see like if you go on our newsroom, you'll see that like there's a product policy form where we actually publish our minutes from these discussions that we have when we're looking at developing and updating our policies. So the second piece is on enforcement, where we're looking at how do we improve our enforcement of our policies, because it's not perfect and it's impossible to be perfect, because we are talking about moderating speech, which is highly contextual, very subjective, very individualistic. But at the same time, we do try to identify like common denominators that allow us to be more proactive in terms of our enforcement. So, and how do we better enforce our policies? So like the work that we're doing in updating our AI and machine learning tools and increasing our language capabilities there. As well as like looking at our human review process and how do we like further make it more efficient? How do we enhance the work that the human reviewers are doing as well? And then all the different tools that we provide and resources that we provide to our users, such as like the tools to customize their newsfeed, the tools that gives them transparency into the content that they're seeing in the newsfeed, the resources like in our safety hub that we provide to users, where it's not just about like tools and resources in relation to the Facebook platform or the Instagram platform, but operating the internet in general, like digital literacy tools, media literacy tools. And then finally, I mentioned already in terms of our policy development partnerships, but it's not just in the policy area that we are having our partnerships. We have partnerships in all the different areas that we work in, because we need those we try to take more of a whole of society approach in how we're tackling a lot of these harmful content, integrity issues, and safety issues on the platform. So as a result of these efforts, the Facebook papers was just a highlight of all the work that we actually and all the thinking that we actually do into all of these different things that like all of these different pillars, right? So like for example, like we introduced like more protections for youths, where we've had more default settings, like very restrictive default settings for youth. So in terms of privacy, to ensure that they're protected from that perspective. And so I think that's kind of how we're kind of looking at all of this. It has nothing, like the Facebook papers, of course, has shared some information, but the information it shared is these are all the things that Facebook or Meta is thinking about on a daily basis, and we have teams working on all of these issues on a daily basis. So I think, yeah, hopefully that addresses your question.
Yes, it does. Thanks, Meg. I want to just have you answer the next question, which is in terms of these regulations that are intended to stem on or better moderate online harms, what has Meta's response been? Can you say there's been a generic approach across South Asia to respond to these regulations?
So in terms of the regulation, of course, we are operating on an open internet, and it goes back to what we were saying about harmonization versus fragmentation, right? At the same time, we need to look at like operational efficiencies. And also like when it comes to digital communication, it's not just isolated in one country. So we have to take a global approach in the way we look at even regulation. So we do try to find, as I said, common denominators across all the regulations in which we can build like our response to, like how do we deal with like takedown requests. We have a global process, we have a global policy, we have global protocols and how to deal with takedown requests. Now, of course, then we have to as these processes and policies occur, we are also taking into consideration the local nuances and local laws. And so that's how we're balancing it, where like you're going, I think Shruti had mentioned like principles-based approach. We take a principles-based approach on all of our approaches when it comes to regulation. So like, and these principles would include like proportionality and necessity, human rights being very, very key, and free expression and free speech being one of the key principles in terms of how we look at things. And we've also like released a human rights policy last year that kind of outlines all of this as well in terms of how human rights is embedded in everything that we do, from product development, product design, all the way to like the ongoing life cycle of the product on the platform for users. So that's one of the key principles in terms of driving how we approach regulatory compliance, as well as how we approach our product governance overall and content governance overall. So I think that's a very important piece. But of course, we have market specialists, we have language specialists, like different like people that are experts in the different markets that we operate in, that provides us with the nuanced views to help us further update our policies in a way that can address the issues within those countries. Which is why if you look at our policies like around hate speech, it's not specific to a country or not specific to a group of people. It gives us flexibility that we can then adjust when needed in each country according to what the harms and threats are in that country. So I think that's important. And then it goes to this point about what Shazeb was saying about this one-size-fits-all approach for regulation. Now, the more prescriptive a piece of regulation is, the harder it is then to have one-size-fits-all regulation. And so this is why I had talked about systemic or like systems-based, outcomes-based, principle-based regulation, where if there's sufficient flexibility in the regulation where it's very outcomes focused, then you're able to have more of a one-size-fits-all approach where you can then try to capture all the different types of platforms, but where they're instead of prescribing specific interventions they have to take, such as taking down specific content or implementing specific controls. Instead, it's more about the outcome that there should be achieved, that all the platforms from a regulation standpoint to provide sufficient flexibility should then like instead it should be where all of the platforms have to reduce the spread of hate speech on their platform. And that could be the outcome that all the different platforms could need to be able to achieve. And it's through transparency that then you're able to then scrutinize how they're approaching it, and through that transparency be able to hold the platforms accountable. So that's that. So I just wanted to address that point as well to what Shazeb was saying, because I thought that was a really important point about like the kind of regulation that we're seeing in South Asia, like in Bangladesh, Pakistan, and India, like, and especially in light of the Digital India Act coming, is that like they want to capture everything. They want to have this broad piece of internet regulation, and that's like a global trend that we're seeing. All these omnibus regulations that captures privacy and content and data security and all of these different issues under the guise of content regulation. That doesn't really work. So that's one of the issues. And then also like this one-size-fits-all approach where there's all these very prescriptive elements that's really targeted towards certain types of platforms that they're trying to apply it across the board. This is why systems-based, flexibility, outcomes-based kind of regulation is a better way of going. And you were talking about best practice models earlier. And so that's kind of the direction that we think it needs to be going, and the conversation needs to be going.
Okay, thank you, Meg. I haven't got any questions in the chat box, but it's an excellent time to continue what you said, which is you're talking about ways of regulation that you feel that social media companies would feel better in terms of pushing through. So let's take it back to the other panelists and ask them what are some ways that you feel that, in addition to what Meg has said, that content regulation or internet regulation would be done better. What do you feel is the best practice? Shruti?
The most important thing, I think Meg has covered a lot of points. One thing that I would like to stress on from my end would be regulation is not just one way to solve the safety and the security challenges. There are multiple other things that also needs to be taken into consideration. And I think the two most important things here is, one, capacity building of the law enforcement agencies, and two is empowering and sensitization of the users themselves. When it comes to the capacity building of law enforcement agencies, we need to take into consideration what are the kind of tools, techniques, skills, already in place for the law enforcement agencies. If we take, for say, the debate around the kind of security thefts on encrypted social media platforms, there we see many kind of research and many studies have suggested that metadata analysis in itself is enough to tackle many of these problems and catch criminals. It's not necessary that you have to break encryption and read the content data. However, here we need to understand that do the law enforcement agencies have the techniques for that? They have the tools to do that. And if not that, then is the government considering and investing appropriately on these ends? Similarly, cybersecurity trainings for the government officials, having more number of officials, faster prosecution of FIRs. India, we've seen reports that FIRs are registered or complaints are filed before NCRB, but NCRB takes months to take cognizance of the matter, or formal filing of FIR is delayed. We also hear that the proper transmission of insights between law enforcement agencies of different countries is a problem, because the MLAT processes through which the information interchange can take place are very slow and archaic. It's important that these regulations and these provisions are amended so that there is seamless transfer of data and seamless sharing of intelligence between the law enforcement agencies of different countries. Another important point is like sensitizing users. Like online safety in itself is something about which users, children and women can be educated right from schools and colleges. The National Education Policy of India is recently been amended, and there's not many new reforms being suggested. It will also be important if we can have provisions for safety education right from schools, and how teachers can be trained on these factors, how parents can be trained better, and accordingly the user experience is better monitored, and children are known what they should be referring to on the internet, how they can ensure a more safe and responsible online behavior. So these are some of the critical things that can be taken into consideration, and most importantly, the multi-stakeholder approach of any policy making. It's important that before a rule or a regulation is promulgated, experts are taken into consideration and their opinion is considered, and accordingly regulations are targeted. It's not just that the law says this, because the law needs to understand the limitations of technology and how technology operates. Without that, it's not possible to successfully implement any regulation. So it's important that experts are considered, their opinion is taken into consideration. The flip side of any regulation is also taken into consideration, that what can be the trade-offs, and accordingly a more balanced approach is adhered to, because when the lawmakers are being informed from different perspectives, only then they can take a more informed decision.
Okay, thank you, Shruti. You changed track and brought to the fore another really important issue, which is it's a whole of society approach, in a sense that is needed. It can't be just, while we are talking about improving regulation, that is one of the answers. It's not the only answer. So thank you for highlighting that aspect. Shahzeb, what point would you like to add on to this?
Thank you very much, Dr. Rao. I'm conscious of the time, so I'll try and keep this as precise as possible. So I think Shruti has quite helpfully summarized some of the most important aspects: capacity building, education of digital rights. Expert opinion should not only be taken, but also incorporated, considered with a degree of importance that it deserves. In addition to that, I think from Bangladeshi perspective, it's very important to depoliticize the process. Really not look at everything from a political spectrum. That's an important consideration. The other thing that's quite important is the timeline. Generally, what happens is, and we've seen this probably in other South Asian countries, but in Bangladesh in particular, we see investigation taking months, whilst an individual is spending time in jail, which doesn't make sense. We've had some unfortunate incidents of some of them dying in custody, which has sparked global outrage. So that is something that should be incorporated in the regulation. In addition to that, there should be I think this was something that was discussed before, that the focus should not be on content, it should be on fundamental rights, should be on human rights. So requirements like traceability, which aims to break end-to-end encryption, or if not break, at least compromise end-to-end encryption. Individuals will no longer feel confident to discuss privately, that knowing that their encryption may not be protected. This may lead to self-censorship. Short turnaround time, as I've said, could lead to preemptive removal of content, so over removal of content, again, resulting in restraint on free speech. So to have those procedural guardrails is very important. In short, that's my view on the matter. Thank you very much.
Thank you, Shazib. Again, very important points, because as you're right, we are coming to the end of this webinar, and all your points are bringing in additional aspects that we haven't covered before. So you've talked about depoliticizing the process. I think that's such a huge issue that we haven't really managed to cover in depth. I think we have to, if we have to cover this issue in depth, we'd be here the whole day. So I thank you for pointing out some of these things that we won't have time to cover. And move on to Shamaila to ask about what do you think would be a best practice, or what can be done differently?
I echo everything that Shazib and Shruti have said. I think that they're very, very important and sort of holistic points, because this is a very complicated and nuanced issue, and I think the blunt instrument that states often take to it through sort of these very controlling sort of forms of regulation isn't really sort of going at the harm that it sort of purports to address these laws and legislation. I would just also like to add that a lot of times there's also a lot of people do not have the answers in terms of what regulation should look like, because in each country there are very specific dynamics, there are very specific political, cultural, sort of structural issues. And it's very important to then also sort of take steps to understand and invest in research that can actually then inform the policies that we make. And I think sort of when we look at sort of internet regulation, I think we need to stop treating lumping all these issues together. For example, you can have very, very straightforward content regulation sort of frameworks for issues such as, addressing child pornography or very straightforward harm. But for other issues, especially when they have to be balanced with human rights concerns, it's very important that it should be done through a meaningful consultative process where everybody's interests are brought to the fore. And I'm sort of, especially in cases where it ends up regulating political speech, speech that should be protected, perhaps sort of really taking the time, even if that takes a really long time, to do an assessment, thorough assessment, work with people on the ground, and then come up with a solution that might not be regulation to begin with. So I think the governments usually start with the question, how do we control the situation? Whereas like sort of it should be started with like, how do we, what kind of sort of a broad range of tools do we have with us? What is the problem at hand, and then address that in a meaningful way. But usually the way that the government works, they sort of tend to lump the internet into one and then treat it as either sort of an economic issue or a political issue or a technological issue, whereas it's all of these and a societal issue as well.
Right. Thank you, Shamaila. I wonder if when these kind of regulations are thought about, how policies or laws, the question is, how can they be flexible enough or sort of broad enough to understand the nuances of this issue, but also flexible enough to constantly update rather than, in my view, from what I'm hearing from all of you, is rather than have this big blunt tool, but rather have it more nuanced and keep revising it as you understand the situation better, could be one possible way of doing it. I have a question that I've got directly here, which is about wanting to hear what the panelists feel about data privacy and data protection in the South Asian context. So, Meg, would you like to take that first?
Well, I just want to quickly go back to what you were saying right now about like flexibility, because there are a couple of initiatives taking place right now trying to explore what that model is. Because, you know, what Shamila was saying is you can't just copy and paste some other country's laws into your country, because it may not apply to it's not solving the same problem. And then also to what Shruti is saying about the whole of society approach or a multi-stakeholder approach that's needed, and that regulation is not the answer. So one of the initiatives that I want to flag is there is a New Zealand Code of Practice for Online Safety and Harms that Sri Lanka now has taken on as a model for adapting it for Sri Lanka as well. For the whole purpose of this New Zealand code and the way it is to help in aid, like what you were saying, Shamila, about needing research, evidence-based policy making. So the purpose of the New Zealand code is to provide this regulatory sandbox where there's a lot of, where its flexibility and transparency is built into that code that allows us to constantly like iterate the code and change and review the mechanisms of the code and the obligations of the code to address the threats of today or emerging threats as well. So that's one piece of the New Zealand code, which is why I think it has appealed to Sri Lanka. It's a civil society-led initiative in Sri Lanka now that has taken what we've done in New Zealand and brought it over to Sri Lanka. So that's one of the key pieces where, like I said, it's a regulatory sandbox with flexibility. Transparency is built into it. There's a governance mechanism that builds in some level of accountability, and it could even be a co-regulatory model if the government decides to get involved in it as well. So I just want to flag that, but there's another initiative that's a more global initiative, and it's called the Digital Trust and Safety Partnership. And that is really looking into like, how do you facilitate accountability through risk assessments, through evaluations and audits, and transparency. And so those two key initiatives are ones that like industry has kind of really like put a lot of effort and investment into right now to kind of hopefully provide a model and educate different stakeholders and policymakers on an approach that is a bit more flexible than regulation, that brings in civil society into the conversation as well, and be part of this regulatory framework. Even it's not a direct regulation, but just a broader regulatory framework to address some of these issues.
Okay, thank you, Meg. Very interesting. I'm going to be looking those up. And I think then a quick question, as we're almost at the end of this session, is, and I think Shruti mentioned this earlier, which is what are the possibilities, like you've suggested, for greater collaboration to have better sharing of best practices, to get more civil society involvement. I wanted to hear from the others also. What do you feel going forward? Is this something that we could have more global cooperation or more regional cooperation in this area? Shazab, would you like to? So just a quick question, quick off the bat.
Yeah, I think it's important to first appreciate that this is not a localized issue. It's not specific to one country, one region. It's a global issue we're facing. Yes, the shades are different for each country, but then the problem is quite global. So it's important to really learn for each country to learn from the other, to understand what the global best practices are, to have more consultation, because not all the countries might have the same level of technical expertise and understanding on the subject. With respect to the online content regulation that is being developed in Bangladesh as we speak, there has been a lot of international collaborations with a lot of multinational companies, organizations, pitching in that this is how it should be done based on the regulatory models of EU, of India, of different countries really. And to a large extent, the government has listened to what these organizations had to say. I'm not too sure if they're going to incorporate it, but to really have that open-minded approach as well. I think that's quite important when it comes to public consultation.
Right. Thank you, Shazeb. Should we ask Shamaila what she thinks about this?
Yeah, I think at least sort of the way civil society is the relationship that it has with the state is quite contentious. So a lot of the engagement is, while we are taking on support, a lot of times it isn't really meaningful engagement. So I think sort of having that at the background, I do think that there is perhaps a lack of perhaps a lack of cooperation between sort of civil society actors within the region a lot of times, and that kind of like sort of conversation and cooperation that perhaps happens in forums such as this, but it doesn't really coalesce into something perhaps like a coalition or a working group that actually sort of strategizes and works, because I think there's a lot to be learned from one another. So I think sort of regional cooperation would be quite, it is something that hasn't been tried in the digitalized sphere in sort of South Asia. So perhaps would be an interesting thing to explore. But I think it's also undercut by the fact that a lot of the countries in the region, sort of that kind of cooperation across the society is also heavily regulated. So, for example, I would completely understand if like an organization based out of India wouldn't want to be publicly associated with an organization in Pakistan. But I think we would, there's a lot to be, a lot of benefits there as well, even in terms of something as simple as sharing research around like, okay, sort of if they're working on sort of resisting data localization efforts by governments, these are the things that you should be looking at, and like sort of vice versa across countries.
Right. Thank you, Shamaila. Shruti, what are your thoughts on this?
I think like I have already highlighted quite a few bits on how we can have more multi-stakeholder approach and how we can ensure that there is greater collaboration. I would again like to re-emphasize on the point that maybe a collaborative approach, not just on a state-wise level or country-wise level, but rather on a more global approach, a global platform, and corporations, multinational corporations, as well as different international bodies and organizations coming together and facilitating these discussions is a critical way. It's also important that the countries they come together, they discuss the approaches, and then a more seamless way, like right now we hear about bilateral treaties, bilateral agreements being signed between two countries. However, it's important that on more principle-based overarching regulatory regime, which is like an international soft regulation of sorts, is proposed and formulated. There are certain international soft laws like the Santa Clara Principles or the Manila Principles that delineate some policies on content moderation or on intermediary liability at large. It's important that the domestic regulations take some of the cues from these international soft laws or the soft principles, and there is more legitimacy granted to these soft regulations, wherein it's some kind of an inspiration for other countries to take inspiration from these regulations, and some kind of incentives is being created for all nations, that a more principle-based and a more similar approach is coordinated between different countries. Definitely in terms of seamless cross-border data flow and like reducing data localization is another critical thing. And for this, it's important that all countries need to have a robust data protection law. We see that the South Asian countries, India does not have a data protection law till now. Even Pakistan and Bangladesh, it's under deliberation. So if we have a robust legislation on that regard, it helps to achieve those adequacy standards, which is essential to have seamless data flows with other countries, maybe in the West, which have a more robust and a more developed data protection regime already. So ensuring that we are in consonance and our legislations and laws are updated and it's up to date with what is happening in other countries helps both economic growth and public security both. So these are some important things that must be taken into regard.
Thank you, Shruti. A lot of very good points from everyone in terms of what could we do about best practices, how can we get global cooperation mechanisms or even regional cooperation mechanisms moving. I think these are things that more and more of us have to be thinking about. The idea that Shruti said about soft laws, best practices, good codes. How do we, get this to have the kind of sandbox idea that Meg was talking about? So we're almost at the end of our time, and it's been I've learned so much from all of you. If I could ask you to end this session with just one statement, and that one statement would be, what are the larger implications for the region with regard to these contestations? We can just end with that, Shazib.
An interesting question. I think the biggest implication that I can think of is on free speech. And it is important that any law that we formulate take a principled approach so as to protect free speech on the internet.
Okay, thank you. Succinct.
Thank you
Perfect.
very much.
I love it. Yes, thank you. Meg, what is your one statement answer to this?
I would agree with Shazeb, but to add on to that layer of free speech, I think there's also the implications of economic growth, where when you start putting up artificial borders around your country, then it's going to definitely stifle economic growth as well. So I think, I'll just leave it there, and then I'll let the others add on to this.
Okay, perfect. Thank you. Shamaila.
I think within these contestations, I would want that the most marginalized communities and actors within each country are centered and made part of these conversations, because they're often the ones that are sort of the last to be consulted, if at all.
Okay, excellent. Great point. Another great point. And finally, Shruti.
As everybody mentioned, I would just like to collate that free speech and privacy and safety. So free speech, privacy on one side and safety on the other side, we see these as being antithetical to each other, but they are two sides of the same coin. And undermining one is definitely going to have a same amount of proportionate impact on the other. So understanding this and accordingly formulating your regulations is important, because if the government and any other body for that matter takes this into regard, then most of our problems will be solved.
Okay, excellent. Thank you so much. And thank you all for bearing with me as we went a little over time. Thank you for the audience for staying on. And thank you for your very succinct last set of thoughts before we left. I'll hand it over to Shavinya to do the closing remarks now.
On behalf of ISAS, we would like to extend our thanks to the panelists and chairperson for an engaging and insightful discussion. Thank you, and we look forward to seeing you at our upcoming events. Thank you.
Thank you so much.